session. Today we're looking at this. We're covering an insolvency update and looking at dealing with distressed assets. To introduce myself, I'm Gail Smith, an associate in our real estate team, and I have particular experience in dealing with the disposal of distressed assets. I'm joined today by my colleague Christina Barr, who is a senior solicitor in our restructuring and insolvency team. So just moving on to what we will cover today. At the risk of repeating something which has probably been said in every webinar you've attended over recent weeks, we are in unprecedented times as a result of the COVID pandemic. Lockdown has resulted in significant restrictions on business activity and may indeed be affecting you personally in your work for what has now been approaching 3 months. And I think easing has been slower than we might have originally expected, and it looks like restrictions are going to continue for some time to come. So there is undoubtedly going to be a significant economic impact. We're likely almost certainly to see an increase in business failures and an increase in insolvencies. So we thought that an update on insolvency might be useful for you in your work. It's perhaps fair to say that many of you, starting out in your careers may not have had much experience of dealing with insolvency sales to date after perhaps a sort of peak of insolvencies following the 2008 recession. Certainly over recent years, we've seen fewer insolvencies, certainly fewer bank-led insolvencies. Certainly the last couple of years have, with the trials and tribulations faced by the retail market, we have seen some higher profile retail insolvencies, and certainly we're likely perhaps to see more of those, and other sectors such as travel and leisure, which we're likely to see business failures which directly result from the impact of COVID-19. For example, I'm aware of the recent high-profile CVA of Travelodge. So we want to provide you with some key learning that will assist you in your work and some practical tips. So first of all, Christina is going to talk about the insolvency process, take you through the insolvency toolkit to look at the main types of insolvency and business restructuring tools that are available to companies in distress and to their creditors. Next, obviously once a company goes insolvent, then the administrator or liquidator or whoever you're dealing with needs to realise the assets of the company. So I will take you through what you need to think about when dealing with a distressed asset, either on the sale side or on the buy side. And then finally, we'll finish just by looking at what's on the horizon and to consider how different sectors might be affected by the economic downturn which we are undoubtedly facing. So the formal part of the session, we're hoping, if we stick to time, will be about 45 minutes. So that will leave good time at the end for questions, which, as I say, you can submit using the Q&A bar. So first of all, I'll hand over to Christina.
Thanks, Gail. Turning now to what insolvency means in practice. In general terms, insolvency is not a term of art. In simple terms, it means being unable to pay the debts due to a creditor. When a company is unable to pay its debts, there are legal processes in place which are designed to realise assets and make a distribution to creditors. There are a number of methods to establish the insolvency, or not, as the case may be, of a party. You may already be familiar with certain statutory tests to determine whether or not a company is insolvent, but for clarity, these are balance sheet insolvency. That's where liabilities are in excess of assets, and cash flow insolvency, where there is an inability to pay the debt as they fall due. In addition to the statutory tests which are available, contracts may stipulate when an insolvency event or an event of insolvency occurs. This may not always be based on the statutory tests or the formal appointment of an insolvency practitioner, so care does need to be taken when considering such clauses. Moving on to the next slide, where we'll be discussing IPs, or insolvency practitioners as they're commonly known. When a company becomes insolvent, it is the role of an insolvency practitioner to manage the affairs of the company and the insolvency process itself. This includes investigating the conduct of the directors of the company with a view to establishing how the company became insolvent in the first place. An IP is also responsible for realising the company's assets and distributing any realisations amongst creditors. There are a suite of insolvency procedures which are designed to achieve such a distribution. In today's session, we'll be focusing on the regimes available for corporate entities, as these are most likely what you'll hear of and what will come across your desk day to day. Insolvency practitioners are highly qualified and are usually chartered accountants, as well as it's called JIEB, Joint Insolvency Examination Board qualified insolvency practitioners. Insolvency practitioners have a special status in either administration or court-appointed liquidations, with an IP being an officer of the court, which means that they have a duty to the court and they are bound to act honourably and fairly. It's worth bearing in mind that regardless of the regime, there are common features. The common features include the appointment of an IP, which in practice means the appointment documents, and is either the notice of appointment or an interlocutor or court order. The date of appointment is important because directors are divested of their day-to-day managerial powers, which means that IPs take responsibility of that role. In addition, we operate what's called pari passu distribution, which in practice means that we operate collective insolvency regimes which are designed to benefit all of the company's creditors. Moving on to look at the order of distribution. During an insolvency process, a company's assets are realised and distributed to creditors in a hierarchy known as the order of priority. Once funds are gathered, they are distributed in a waterfall fashion, with secured creditors such as floating charge holders being paid first, with preferential creditors next, and unsecured creditors being paid last, if there's sufficient funds at all to make a distribution to unsecured creditors. If there's funds left after that, which is very unusual, members will receive a distribution, and although this is unusual, it's not impossible. Moving on to discuss insolvency regimes. The insolvency regimes available include administration, liquidation, receivership, and CVA. For each insolvency, IPs have a particular name, which you'll no doubt have heard, but I'll just go through them just now for certainty. These are an administrator, a liquidator, a receiver, and a supervisor. It is important that the insolvency regimes are differentiated because the terms are not interchangeable. Whilst there are aspects of the different insolvency regimes that are similar, each insolvency vehicle has its own structure. And we're now going to look at each regime in a little bit more detail, and we'll move on to administration. The purpose of administration is defined by statute and is to rescue the company as a going concern, to achieve a better result for creditors than a winding up, and to realise property to make a distribution to the secured and preferential creditors. The most popular way for administrator to be appointed is using the out of court method by way of filing the appropriate forms with the court. An administrator may also be appointed by the court where a petition is presented to the court for an administration order. In an out of court appointment, an administrator may be appointed by a qualified charge holder, the company, or the directors of the company. If the appointment is by the court, the administrator may be appointed by qualified floating charge holder, the company, the directors of the company, or a creditor. On filing a notice of intention, on filing a notice of intention to appoint, A company receives a protection known as an interim moratorium, and an interim moratorium will also take effect once a petition is presented as well. Once a notice of appointment is filed or a petition is granted, the interim moratorium is replaced by the statutory moratorium. Now, the statutory moratorium is designed to offer a wide range of protections to the company from its creditors, and most notably, it prevents legal proceedings from being presented against the company without the prior consent of the administrator, and if the administrator will not consent, then the court will have to give that permission. Once appointed, the directors are stripped of their day-to-day managerial role, and it becomes the administrator's responsibility to manage the company. The role of an administrator is to realise assets and make distributions to the company's creditors. An administrator is obliged to act in the interests of the general body of creditors as a whole. Administration is a highly favoured restructuring tool, particularly due to the powerful statutory moratorium which protects the company from its creditors. On appointment, an administrator is in office for 1 year. After the expiry of 1 year, a secured creditor may consent to the extension for a further 1 year period, and thereafter applications must be made to the court. The ultimate aim of an administration is for the company to be rescued. However, in practice, this is very rare. Therefore, the exit route of an administration tends to be either creditor voluntary liquidation or dissolution. Moving on now to consider liquidation. Liquidation is also known as a winding up, and it is used when a company becomes insolvent and is no longer in a position to continue to trade. It is a terminal process, which means that once a liquidator has realised all of the company's assets and dealt with its affairs, the company will ultimately be dissolved. This obviously contrasts to administration, where one of the aims is to rescue the company. There are 3 types of liquidation: compulsory liquidation, creditors voluntary liquidation or CVL, or members voluntary liquidation, MVL. MVLs are only used to wind down a company when it is solvent. Compulsory liquidations and CVLs arise when a company is insolvent. We will focus today on compulsory liquidations and CVLs, as both relate to insolvent liquidations. A company may be wound up by a meeting of creditors who resolve to wind up the company, and this is known as the out-of-court process. Alternatively, a petition can be presented to court by the company, its directors, or its creditors. If the share capital is below £120,000, the petition will be presented at the appropriate share of court, and above £120,000 in terms of share capital, this will be presented at the Court of Session. A provisional liquidator at any point, can be appointed at any point up to the making of a winding up order. It is the role of a provisional liquidator to safeguard and preserve the company's assets pending determination of the winding up petition. A provisional liquidator can be granted the power to sell and to continue to trade the company where good reason can be shown. Although this is unusual, the courts will grant such an order if they are satisfied that this will ultimately benefit the creditors. An interim liquidator is appointed by their court, but their appointment has to be approved by the majority at a creditors' meeting. Otherwise, an application to court requires to be made. Once either a meeting of creditors, or if there is no approval, the court have confirmed the appointment of a liquidator, the directors are stripped of their day-to-day managerial role, and it becomes the liquidator's responsibility to manage the affairs of the company. There is a very limited moratorium available for liquidations, which provides that on appointment of a provisional liquidator, no action or proceedings shall be commenced against the company unless there's leave of the court. But again, in comparison to administration, this is a very limited moratorium. Once all assets have been realised and distributed, as a terminal process, exit from liquidation is by way of dissolution and strike-off. There is no set period prescribed for the term of a liquidator's appointment, and they can indeed run for many years. Moving on to look at receivership. I will touch briefly on receivership, as it's likely to be a term that you're aware of, but note that the appointment of a receiver is uncommon, as it only applies to floating charges granted before 15 September 2003, which are of course becoming less and less. Receivership is designed as a mechanism by which a secured creditor, or floating charge holder, can recover monies advanced through their security. The role of the receiver is to recover charged property for the benefit of the charge holder. One of the reasons I mention this is to highlight that this should not be confused with the official receiver, which is a strictly English provision, and in Scotland we do not have an official receiver. Moving on to look at company voluntary arrangements, or CVAs. A CVA allows a company to enter a contractual agreement with its creditors with the aim of compromising debts due by the company, so that the company avoids insolvency and is permitted to trade on with the management remaining in place. A CVA must be approved by the creditors, representing 75% of the debt value. Once the CVA is approved, it is binding on all creditors. A company is with its management team and directors in control. Therefore, once a CVA is approved, a supervisor is appointed to monitor the company's performance and ensure that the company is able to meet its ongoing obligations. The CVA proposal determines how long a CVA will run, and if the CVA is successful, the supervisor will be discharged and the company will be handed back to the management team or the directors. The company will continue to trade, having received debt forgiveness from its creditors. CVAs have been particularly popular in the retail sector, but during coronavirus, we have seen them used in the hospitality sector. CVAs tend to be favoured by directors and the management team because they can retain control, at least in theory, and they don't seem to have the same stigma attached as other insolvency vehicles. CVAs are also particularly popular as they can be used in hand with administration, and notably, this is the only circumstance where two insolvency regimes can be used in conjunction. Moving on to have a look at pre-packs. A pre-pack is a term used to describe the sale of all or part of a company's business and or assets, and is negotiated with a purchaser prior to the appointment of an IP. The sale documentation is signed and implemented either immediately or shortly after an IP is appointed. Pre-packs have been criticised in the media for lacking transparency and do give rise to some serious concerns in relation to lack of transparency and a lack of consultation with creditors. Due to this criticism, the guidance called the Statement of Insolvency Practitioners, or SIPs as they're more commonly known, SIP 16 has been introduced to make this process more transparent and to make sure that IPs obtain the appropriate value for the business and assets that are sold. Now, I do appreciate that that is a whistle-stop tour around insolvency, and if you do have any further questions, you can upload them in the appropriate box, or you can get in touch with me directly for more complex questions. I'll hand over to Gail now, who will talk you through points to consider when dealing with a distressed asset.
Okay, thanks very much, Christina. I think that was a really useful overview of the different insolvency processes and restructuring tools. As Christina has said, do post your questions if you have any, just if they come to you following that session, that part of the session. So I'm going to look now a little bit more at dealing with distressed assets. Obviously, property assets can be a key asset for maximising returns to creditors in an insolvency. Obviously, Christina has mentioned the different insolvency regimes. So what I'm going to talk about regarding the disposal of property assets will be relevant to any disposal from an administration, a liquidation, or a receivership. Although, as Christina says, we really don't see very many of those these days. So I will talk perhaps about administrators or liquidators, which are really interchangeable as well with talking about insolvency practitioners or IPs, which is, as Christina said, is the more global term used. I think we are going to see more assets coming to the market out of insolvencies, and these are going to be an opportunity for some of your clients, and there are those that will be able to take advantage of that. So I think the two main things to consider when dealing with a distressed asset sale compared to a normal sale, first of all, there is usually a lack of information, and secondly, any contract that you will go ahead on is going to be on standard insolvency terms. Just looking a little bit more about the question of information, it's perhaps not unexpected that when an insolvency practitioner steps into a company which has gone into insolvency, there will be a lack of information. You may be surprised, however, at just how little information is sometimes available to the insolvency practitioner. The other issue is that even if information is available, the insolvency practitioner can't have any certainty that that information will be complete. So you can see from a buyer's perspective that this is a practical issue, but it is also an additional risk which any buyer will have to manage. I've obviously mentioned standard insolvency terms, and I'm sure that's a term which you have heard of, but what does it mean? The two main things you need to be aware of is that in a sale contract, the insolvency practitioner will certainly look to exclude any personal liability of the administrator. This really reflects, as Christina described, their status as someone appointed by the court to perform a statutory function. They obviously have their own duties to the court and to creditors. So it wouldn't really be appropriate for them to expose themselves or their firm to personal liability. So they will certainly look to exclude that in any contract. They will also not give any warranties, for example, in relation to title, the property, its condition, or anything else. I should perhaps explain a little more about what a warranty is. Effectively, that's a contractual representation by a seller to a buyer, so that in the normal course, if a warranty was given by a seller, you may have a claim against them if it turns out that that representation wasn't true. The situation is different if you're dealing with buying a distressed asset. The administrator or liquidator will want specifically to exclude any warranties, partly because they don't have information, but mainly because they will not want to risk any claims against them. As I say, they certainly won't accept any personal liability, but it's perhaps worth exploring a little bit more about other types of claims. Even if warranties were given out by the insolvent company, and even if those claims would only be against the insolvent company, then they won't be given by an insolvency practitioner. They will effectively be selling the property as seen. The argument is that if an insolvency practitioner contracts to give any warranties, even if that's only on behalf of the insolvent company, then any claim will be treated as an expense of the insolvency rather than an ordinary claim. I can perhaps explain that with a story, which I'm calling the football pie story. So imagine if a well-known Glasgow football club went into administration. Some of you, this may just now be a historic story, but the club may have a contract with Tasty Pies to supply pies for match days. If Tasty Pies haven't been paid for the pies they supplied for last week's game before the club went bust, then they have a claim against the insolvent company, just like all the other debtors. But if the administrators, knowing that at next week's match there will be hungry fans looking for their pie at halftime, if the administrators continue to place orders on behalf of the company so that Tasty Pies will continue to supply pies, then that will be treated differently. What's due to be paid for those pies becomes an expense in the administration. Effectively, obviously Christina explained the waterfall of how claims are dealt with, but effectively it becomes a priority claim to be paid ahead of all other claims, perhaps even the administrator's own remuneration, depending on the circumstances. So You can see that in entering into any contract to sell property, the administrators will be at pains to ensure that they don't undertake any obligations or give any warranties or undertakings, even on behalf of the insolvent company, because they would want to avoid any such claims. So moving on, against that background, what do you need to do in practice? First of all, I'm going to think about some practical tips if you are acting for a seller in the disposal of a distressed asset. I've mentioned there, check the title. So the first thing you'd want to do is to get hold of the title for the property, review this and flag if there are any issues. For example, I've recently dealt with a sale where there was a preemption right in the titles. Now, we don't see so many of them these days, but they are still out there. And that was certainly something that we needed to deal with before we commenced the marketing effort. The other thing I've mentioned there is to identify any risks from your survey, such as access. It's unlikely that the administrator will have funds or the desire to take steps to deal with any issues. The buyer will be taking the property as seen, but it does help to flag issues and manage the seller's expectations around price. Another thing to think about is your sales particulars or any heads of terms which might follow from that. You need to make sure the buyer is aware that this is an insolvent sale and the property is being sold as seen. We would certainly suggest that you include specific wording in any sales particulars to state that the property is being sold on insolvency terms, and certainly we can provide wording for that if you needed it. Really, you want to make sure that the buyer has their eyes open and that anyone bidding on the property has their eyes open when they make their bids. Essentially, you want to put the onus onto them to price the risk. Just a more practical point on EPCs and action plans, if those are required. These are a statutory requirement, but it can often be the case that the administrator doesn't have those, it's not with the paperwork. Generally, from my experience, they're happy to accept that there's a statutory obligation to have these, so they will arrange that. So it's worth finding out early doors if there is one for the property, and if not, obviously that's something you will have to instruct so that you can have it available for any sale pack. I'm going to move now to look at the flip side of what you maybe need to think about when you're acting for a buyer. I've explained already that there is likely to be a lack of information, and even if there is information, that will be provided only on a non-warranted basis. The buyer's lawyer should be advising the buyer of the risk being taken, as there will be no comeback against the seller, but obviously it's a risk that you need to be aware of so far as your client is concerned. They're obviously going to be relying very much on their own diligence. So in terms of your role and inputting into that, from your site survey and walk round, think about what the issues are that the buyer might need to think about. I've mentioned some particular matters there. Think about planning, perhaps have a look at the planning portal and see what the history is. Look at the site and consider matters like access or services. One other thing that I've highlighted is that generally the administrator or liquidator will not give any warranty about any other any authorised users or unauthorised users on the site. So do check if there's signs of occupation or any other signs of activity on the site which should be queried. So it's really a question of doing a bit of digging about and also understanding what the buyer wants to do with the property so that you can properly identify any risks. I've mentioned obviously technical input as well. So does the buyer need any technical input in addition to the survey which you can provide? I have mentioned there in particular investment properties. there are particular issues perhaps to consider when you're dealing with the purchase of a distressed asset, which is an investment property. If there are any leases in place, try to find out what information is available regarding arrears and also the service charge, whether, for example, there might be a deficit in the landlord's contribution. I should say that obviously whilst information might not be warranted or given by the seller, you can still ask the question and you can still ask for information to be provided. One thing to flag is that the insolvency practitioner will look to try and apportion rent at completion on the basis of rents received rather than rents receivable. Certainly, it could be that there may be issues with arrears. That might be one of the reasons that the landlord has got into difficulties. So that is also something to factor into when looking at price. And that takes me to really the main point of looking at your diligence and making your inquiries about the property. The main issue for you is to make sure you appropriately price the risk of taking on the property on the as-seen basis. I'm going to move now just more to look at what lies ahead. I think Christina will speak a little bit about what's on the horizon for insolvencies. Oh, Christina, I think you're still muted.
One thing I had to remember is to unmute myself, and I've managed to forget that. Looking ahead, it's unclear precisely what the impact of COVID-19 will be, but what is very clear is that industries such as hospitality and leisure are going to experience reduced capacity, and that can either be in terms of footfall with clients coming into their businesses, or in relation to the services that they can provide. This may mean that they need to restructure their own businesses, not in the formal sense, but by reducing staff and operating a more owner-led model. Or it could mean that companies require to diversify in order to remain viable in the market. It's also possible that companies may have to be creative and find a market in order to survive. And in fact, earlier this week, I came across an interesting case of a Michelin-starred restaurant in London called the Ledbury, and they've confirmed that until social distancing is eased, it's simply just not viable for them to reopen. Another example is La Caprice, which is a restaurant which all the stars go to, and they've confirmed that they are closing until further notice. But that's because their lease has come to an end. But until schemes like furlough are completely closed down, I think there'll be a lot of businesses that simply won't open, and it's not as simple as just, putting the cash register back on and opening up again and, unbolting the doors. So I think it's tricky for businesses. There are going to be a lot of difficult decisions made, and a lot of it is contingent on the advice from the government. And I think also as well, from a buyer's perspective, buyers are scared just now to go out generally and to start going back to whatever normal may be in a couple of months. So what I can say with certainty is that we don't know, but situations like the Ledbury restaurant may trickle down to other restaurants, and certainly will have an impact on footfall, which will have a huge impact on cash flow. Okay.
I meant to say actually, and just remind anyone, if you do have any questions, as I say, the button is there if you want to submit any questions. I think that's right. The shape of how things are going to recover is probably difficult to predict, and certainly there's been a lot of speculation and discussion regarding what recovery will look like and what the impact is going to be on businesses. I think at the outset of this, we were talking about a sort of V-shaped recovery where we might see a fall off and then a regaining of demand back to kind of former levels. I suspect that people's thinking has moved on that, and as lockdown has continued and as the furlough scheme perhaps reaches an end, then we might be less likely to see that kind of predicted sharp recovery. and it might even be that if there is a recovery, that there's going to be a subsequent market fall, as we see the knock-on effect. And we've obviously talked about the possibility of failures within the hospitality and hotel sector as a result of COVID, but there may also be kind of knock-on effects. And it may be different for different sectors. One of the other issues is valuations. There are current practical difficulties, as I'm sure you know, in even getting valuations done. So there is still lots of uncertainty, but as restrictions ease, we might be able to get a clearer picture of how valuations are holding up and what the opportunities might be. So, I mean, I've talked a bit about the price adjustment that you see when dealing with a distressed asset. I mean, you guys may know as much as we do about the markets, but we are certainly aware of clients of ours with current requirements who would have the appetite to take advantage of opportunities for a price adjustment where an asset is distressed. Certainly in terms of sectors, we have clients in the hotel and leisure sector, which reflect a belief that they would be willing to take advantage of opportunities, particularly if they're already in the sector. They see that there is demand out there, the demand will come back, and that therefore they are still seen as a good, perhaps not short-term investment, but certainly a medium-term investment. I think we'd have to recognise, however, that there might be a different picture across different parts of the hotel and leisure sector. For example, if your main business is conferencing, that may be a less secure picture, as the demand for large-scale conferences perhaps takes a longer time to grow back. Obviously, we have touched upon retail, which has been a sector that's been under pressure for some time now. I think we might begin to see an additional pressure. We've seen a steep drop in rent take for landlords, which may have a second tier effect where investment landlords are affected by significant falls in income, particularly given the tenant protections which have been put in place as a result of COVID-19. So we may begin to see those types of landlords under pressure too. And again, we're in a situation currently where lenders are giving forbearance, but obviously that is again a picture that may change, although there's not any sign of that anytime soon. Just perhaps to end on a more positive note, I have mentioned there student accommodation and build to rent. The market sense we are getting is that this sector is still seen as strong, and the belief is that there is resilience in demand in that sector, even with the difficulties that universities might be facing. There is still seen to be a demand from foreign students as well as UK students. So far as student accommodation is concerned, and the talk, I think some of you from Knight Frank, I think you colleagues of mine were at your recent presentation on that, which was talking very positively about that market. So it might not all be doom and gloom, but I certainly think we are going to see some distressed sales coming to the market. That is really the end of our formal part of the session. So I was just really going to move on to any questions and answers that you might have. So I'll just have a look and see what is there. Okay, Christina, I think this is probably one for you. It's a question about why would you go for a CVA rather than an administration?
Okay, well, in terms of a CVA, one of the things that you can do that you can't do in admin is you can deal with one particular class of creditor. Whereas in an admin, as we've discussed earlier, an IP must act in the best interest of the general body of creditors, which is the pari passu distribution. Again, another thing we've discussed earlier is that the management team can retain remain in control of the company and retain decision making, etc., etc. And it's also seen as a much more palatable form of restructuring rather than formal insolvency, which is seen quite negatively by the public. One of the major benefits of an administration is, of course, that you have the protection of a statutory moratorium, which is one of the main reasons why you would see both running concurrently. I hope that answers the question, but if anyone does want more detail on that, then I'm happy to answer those, and my details will come up on the very last slide.
Okay, yeah, I think that's true, and certainly CVAs, we've all become a bit, we've seen a lot more of them, we've become more aware of them, but it's something to bear in mind. If they come across your desk or your client's desk, then it's something not to be ignored. If there are proposals from a CVA, there is a time for responses, and you can challenge what category of creditor you might have been rated as in those. So it's worth highlighting, though, that timescales are tight. So obviously it's not something to be ignored if it comes across your desk. It's certainly something worth getting advice and legal advice and input on. There's another question, which is more of a kind of practical question around the buying distressed assets. Obviously, I mentioned issues such as access, and there's a question about what other solutions might there be for dealing with these types of problems. I think it's worth mentioning title insurance, which can be available for a range of issues. It can be available, for example, for dealing with a lack of planning or a lack of completion certificates, certainly, not perhaps planning itself, but a lack of completion certificates and lack of, so that is something to look at. It can also deal with access issues. It is often available at fairly reasonable cost. Obviously, the premium usually reflects the property value, but it certainly is seen as really a commercial solution sometimes for dealing with the lack of information or the risk that you might be taking. It's helpful to add as well that obtaining title insurance can also be useful to ensure that the buyer can satisfy their funder. So they may have a funder in the background, and they will also need to satisfy them on title too. So it is something to think about if you're acting on the buy side, sorry, if you are aware of issues. It's something, perhaps if you do flag those, it might be that the seller won't be prepared to pay for title insurance. So again, it's something that you might want to factor into the cost and factor into your bid in terms of price. There's not really there's no more questions coming through. So unless anyone has a burning question that they want to add to the taskbar now, that someone's just commenting, I think they missed the beginning, and just to reassure you, the session has been recorded, so if you did miss part of the session, then it will be available afterwards. But they've asked a question about how the debt markets view distressed assets. I'm not sure I fully understand the question in terms of. Are you talking about how funders look at distressed assets? I don't think there's any particular issue in terms of how funders would look at the viability of a distressed asset. They will fund them in the usual way and look at the usual questions of kind of loan to value. So I don't think there's any particular issue in terms of how funders would see distressed assets and the purchasing of them. I don't know if that answers the question, but if not, you can type your question again. Yeah, as I say, it is perhaps one more for funders in terms of how they will look at I'm not aware that debt wouldn't be available. I think lenders will lend on the purchase of a distressed asset just like any other asset. Whether it would have an impact on the loan to value ratios, I'm not sure. I think that would probably be a more specific question for funders as to how they look at things. And obviously that the loan to value ratio again also may depend on the sector class that the asset is in. So hopefully that answers the question. There aren't any more questions, so hopefully that has been helpful for everybody and has taken you away at least from your inbox for a while. Obviously, if there are any further questions, don't hesitate to get in touch. Our details are on the screen there, and we'll leave those up for a few minutes. But we'll close the session now, but feel free to keep adding questions if you have any, and if you leave your details, we can come back to you on them. But otherwise, thank you from me for coming along today, and enjoy the rest of your day.